Okay, hi, my name is Jason Greller. I'm an attorney in Madison. Residential real estate transaction specialist is what I would call myself, and I'm here up at the Dells giving a presentation today on hot topics in residential real estate. And today I focused on a couple of issues that are of some interest to me and some interest, I think, to the bar. The first issue I talked about today was the financing contingency in the offer to purchase. As some of you may know, the WB11 requires a buyer to deliver, along with their loan commitment, written authorization directing that the loan commitment be delivered to the seller. And we've seen a number of addendum prepared by brokerages that go ahead and modify these roles and responsibilities. And I wanted to take a look at that. Some people out there have opined that if a buyer doesn't deliver that written authorization, that the seller could terminate the contract. And I explore that issue. And I also explore the issue as to whether or not some of the addendum that have been prepared by the brokerages that relate to this provision modify the rights and the responsibilities of the parties under the WB11. The short lesson that can be learned from that particular conversation is that you should be really careful when working with these brokerage addendum. You should be looking at the language. Do not assume that it says what you think it says because you've seen it before. All of these ones are different, and some of them really drastically change the rights and responsibilities of the parties. You also want to make sure that when you get a loan commitment, that you're making sure that it matches up with what the offer says needs to happen. Do not be afraid to make the call. Call people and find out where's my written authorization or where's my signed loan commitment. Get it so you make sure that your seller has got the buyer locked in, or that if you're the buyer, that you've locked them into the closing. The second thing that I talked about today is the real estate condition report. And one of the things that I've been concerned about over the past couple of years has been the disconnect between the WB11 and the real estate condition report. Seems to me that the real estate condition report and the disclosures that are made by the seller should sync up with the representations made on page 2 of the WB11. And that has not been the case for a number of years. Now, the Wisconsin Realtors Association has taken a crack at trying to solve that problem. They've produced a 2- and a 3-page real estate condition report that address that issue. And one of the things that I talked about today was whether or not a seller really wants to use those particular documents. Who do they benefit when looking at those forms? Does it benefit the seller to be asked all these additional questions that go up and beyond the real estate condition report requirements and the offers requirements? And so what I've done is I went ahead and I drafted a real estate condition report that satisfies the statutory requirements and also addresses the issues that are raised in the WB11. So it's bare bones to protect your clients, and I would encourage you to take a look at that in order to avoid any potential malpractice risks. The last thing I talked about today were FSBO transactions and flat fee MLS transactions. And certainly we've seen a lot of growth in the use of these particular devices by buyers and sellers over the course of the past few years. And one of the major concerns that you need to have when representing flat fee MLS sellers is whether or not you have an understanding of the commission structure. And there are a couple ways of looking at that. The most important thing is to understand, one, whether or not your seller is on the MLS. Number two, if they're on the MLS, have they made an offer of compensation? 3, if there's no buyer agent that's involved in the transaction, are you assured that the buyer doesn't have a relationship with an agent, or whether the buyer has done something that's created procuring cause for a selling agent? The reason that you need to be careful about this is it's possible that you could end up at closing and a commission could be due even though you didn't contemplate it on the front end. So a couple of things here that we discussed today. They're basically designed to try to keep you out of trouble and uncomfortable conversations with your buyers and sellers after closing. Thanks so much.